Hello students and welcome to the next session. We will continue from the last session. So in the last session what we have studied, let's quickly go through because we have not completed that topic. So we have started with director. We understood the board of director, then director definition, legal position of the directors, then company to have board of directors, the minimum and the maximum number, then women director, resident director, independent director, we are going to talk about them in detail. Then other requirements for the appointment of the director. The dean, which is the prerequisite condition for the appointment of director. Directors, how they are liable to get retired. Other requirements of for the appointment of director we have discussed. Obligation to indicate dean. So all these provisions we have discussed in the last lecture. So now let's move on and understand. We will try to first understand the disqualification. Then we will talk about the duties of director, vacation of the office of the director, resignation, all those parts first, and in the last we will talk about the types of directors once again. So let me just give the heading disqualification. For appointment of director. Disqualification for appointment of director. So section is given 164. Okay, so this particular section contains various grounds for the disqualification for appointment of a director. So a person will not be eligible to become a director of a company if he will fall or suffers any kind of defects or disabilities or disqualifications given under this particular section. So law nowhere prescribes any kind of professional or educational qualification for a director to become the director, except there is only one rule: to become a director one should obtain the DIN, that is DG, that is director identification number. So which are those grounds which are given over here as a disqualification grounds? So it states that a person shall not be appointed as a director. A person shall not be appointed as director if he is of unsound mind, if he is an undischarged insolvent, if he is an undischarged insolvent, if apply to be adjudicated as an insolvent and his application is pending, if he has been convicted by a court minimum period of 6 months if an order disqualifying him has been passed by a court, tribunal, if he has not paid any calls in respect of shares of company, if he has been convicted of the offense of dealing with transactions if he has not complied with the provisions of Dean. Okay, so these can be grounds for the various ground for the disqualification of a director. So here one by one we'll again go through it. If he is of unsound mind, so and he has been so declared by the you can say competent court for that matter. Okay, and if he is undischarged insolvent, again if he has applied to be adjudicated as insolvent and his application is pending, then also even if his application is pending in the competent court of law, then also he is not eligible to be qualified as a director. So that becomes one of the disqualification. If he has been convicted by the court, okay, for a period of 6 months, and after that a period of 5 years has not elapsed, so after 5 years only he can be eligible to become a director. If an order disqualifying him has been passed by the court or tribunal, okay, so court and tribunal has passed some kind of order disqualifying him, then also he will not be eligible to become a director. If he has not paid any calls, see, call money he has not paid, and in respect of the shares in holding in the company, if he has been convicted of the offense of dealing with the related party transaction, so any offense relating to the related party transaction he has convicted for that, then also he will not be eligible to become a director. And if he has not complied with the important provisions relating to the dean, that is director identification number, then also he will not be eligible to become the director. So this disqualification, okay, Even under subsection 160, subsection 2 of 164, it prescribes some kind of disqualification addition to that, where he has committed as a he has been in default. Okay, he has not, wherever he was a director, his name has not filed, he has not filed, the company has not filed financial statement or annual returns for a continuous period of 3 years, and his companies had failed to repay the deposits accepted. So for that reason also, okay, he may be disqualified. But these are some of the reasons which are noted over here under section 164 subsection 1. Now we'll talk about section 165. We will talk about section 165, which says that maximum number of directorship, maximum number of directorship. Okay, so this provision says that, okay, under 165, a person can hold, okay, maximum number of how many directors. So person after commencement of this act shall not hold office of as a director, including any alternative directorship in more than, okay, 20 companies at the same time. So what does it state? A person, we can just person shall not hold office as director, including any alternate directorship in more than 20 companies at the same time. Okay, so person can become a director in up to 20, in maximum 20 companies. More than 20 companies he cannot become a director, which includes a alternate directorship as well. So this is one of the criteria. So out of the above limit of this 20 companies, the maximum number of public companies, okay, will be 10. So you can say that the maximum number of public companies shall not exceed 10. Okay, so it shall not exceed 10. So these particular limit one has to just remember. The members of the company may by special resolution specify any lesser number of the companies in which a director of the company may act as a director for their respective companies. And there will be punishment, okay, if a person accepts more than that, then there will be punishment. He shall be liable to fine of rupees 5,000 for every day of default. So what is the penalty? Fine of rupees 5,000 for every day of default. Okay, for every day of default. After understanding this particular provision, now we will move on to understand the duties of the director. Now the duties of the director in the erstwhile company law was not specified, but under the Companies Act 2013, duties has been specified under section 166. So let me put duties of director. Duties of director. So these are the statutory duties, you can say, which has been prescribed under section 166. So what are his duties? One by one we'll plus try to understand. He shall with AOA shall act in good faith in order to promote objects of the company he shall exercise reasonable care skill and diligence he shall avoid conflict of interest he shall not achieve any undue gain or advantage he shall not assign his office. Okay, so these are some of the statutory duties we can say under section 166. So one by one we'll try to understand. He shall act in accordance with the articles of association of the company. Okay, so it is his duty that he should properly follow. He should first understand the articles of association of the company, which are framed or approved by the shareholders of the company, and he should act in accordance with that. So he should not go beyond it. He should not enter into any kind of ultra virus transaction in the name of company. So he should act in accordance with the articles of association of the company. He should act in the good faith, and he should take into consideration always the objects of the company, okay, and it should be for the benefit of the company. So in good faith he should take the transaction in order to promote the objects of the company for the benefits of the members as a whole, and he should always try to work in the best interest of the company, its employees, various stakeholders, and for the protection of environment as well. He shall exercise, so he should act in the good faith in order to promote objects. He shall exercise his duty with due and reasonable care, then skill and diligence, and he should always exercise the independent judgment, because he is a kind of decision maker whose independent judgment will be important, okay, to take the decisions for the company, good decisions for the company. So he shall exercise his duties with the due care, reasonable care, and skill and diligence. He shall avoid the conflict of interest. What does it mean, the conflict of interest over here? Okay, so he shall not involve himself in a situation which he may have a direct or indirect interest that may conflict with his position. So like the relative party transaction, he may not get involved in the decision making like that. He shall not achieve any undue gain or advantage. That is the basic requirement from the director, because he is holding that position of the decision maker. So he shall not achieve that particular undue gain or advantage either to himself or to his relative, okay, partners or associate. And if he is found guilty of making any undue gain or earning of it, then he will be liable to pay that amount to the company. He shall not assign in his office. Very important. See, once you are appointing a director, he should not give those powers or subdelegate those powers to anyone unnecessarily, or he should not assign that office of directorship to anyone. Okay, he has been debarred from doing that, and if he is doing so, then that transaction will be treated as the void transaction. Okay, it will be invalid in the eyes of law. And if any director does not contravene the provisions, then he shall be liable for a fine of minimum rupees 1 lakh to maximum 5 lakh rupees. So these are the specific duties which are given under 166, but there are some other duties also, like he is supposed to file various documents, then he should convene the general meeting, he should attend the board meetings, he should disclose the interest, to approve annual financial statements, to approve and attach the board report in the annual report, to appoint the first auditors. These are all the separate, okay, provisions which are scattered provisions, you can say, somewhere in the act, which are not incorporated under 166. The 166 talks, this section talks about all these particular powers. Okay, there are other powers as well. Okay. So we can just mention some other duties in Companies Act 2013. One by one we'll try to just put. To file various documents, to convene general meetings, to attend board meetings, to disclose interest, to approve annual financial statements, to approve and attach board report, to appoint first first auditors. So if you remember, we have already talked about all these particular duties earlier in various other sections. To file various documents, convene general meetings, to attend board meetings. Board meetings, the topic is going to come. To disclose interest, to approve annual financial statements, approve and attach board report, first auditors, etc. Okay. So far we have studied 3 different sections. I hope you have understood. Just make a note of all these points. Maximum number of directorship, then we talk about duties of director, very important question from exam point of view. Now we will talk about vacation of office of director. Vacation of office of director, which is given under section 167. So we says that okay, the director will have to vacate his office in some provisions. So the office of the director will become vacant in case if he incurs any disqualification. If he incurs any disqualifications as per section 164. If he absents himself from all meetings of boards, all meetings of duty held during 12 months, if he contravenes related party transactions provisions and section 184 if he becomes disqualified as per order of court, tribunal, if he has been convicted for more than 6 months. Okay, so any disqualification as per 167 164 if is falling. Okay, so for that reason he has to vacate the office if he absents himself from all the BOD meetings for 12 months. Okay, without the leave of absence. If the board has not given the leave of absence and he remains absent for all the meetings, then that can be one of the criteria. So related party transaction was section 184, where he has to disclose the interest to the company, is not disclosing it. As per the order of the court, if he has been disqualified or if he has been convicted for more than 6 months, then all these can be the grounds for the vacation of the office. So sitting director will have to vacate the office of the director. So private company may provide other grounds also, okay, for the vacation of the office. In addition to this, if the person functions as a director even after he is knowing that he has to vacate the office, then he shall be punishable with imprisonment of 1 year or with fine of rupees 1000 to 5 lakh or with both. So we can say that what can be the penalty or punishment for contravention. So there can be either imprisonment or fine up to 1 year. Up to 1 year imprisonment can be there, okay, or fine of rupees 1 lakh to rupees 5 lakhs or with both. So he has to be very careful. So we have talked about now, okay, vacation of the office of director. Then we will talk about resignation of director. Section 168. Okay. So the provisions regarding resignations are given under this particular 168 along with the rules. So he may resign by giving notice in writing to the company. The board shall on receipt of the notice take the same. The company shall within 30 days, okay, intimate the register of the companies. A director may resign by giving notice in writing to company. then company shall within 30 days inform ROC in DR12. DR12 is the form. The facts should be mentioned in board report. Such director will also inform ROC within 30 days in DIR 11. Okay, so director will have to give the notice in writing that he wants to resign from the company. So that has to be given to company. Then within 30 days company will inform to the ROC in DR 12 form by filing it. The facts should be mentioned in the board report, and again there is a second check mentioned over here that such directors who is going out will have to give the notice in will have to inform the ROC in DR 11 form. So in two ways ROC will come to know about the resignation of the director. So this is about the resignation. Removal of director. This provision is given in the two ways. Okay, under section, first one is by shareholder. By shareholder under section 169, and by tribunal. So tribunal is also empowered under section 242. Okay, so the 169 provides for the removal of director. So like shareholders have authority to appoint them, at the same time they have authority to just remove them by passing the ordinary resolution. But when the director is appointed by the tribunal, he cannot be just removed by passing ordinary resolution. Okay, special notice is required to be given, representation will be required, and all such criteria can be given. So director may be removed by the tribunal where an application has been made under section 241 for prevention of operation of management. So in that case they may terminate him. So these are the small provisions. Then there are some miscellaneous provisions, like company will have to maintain a register of directors and KMP under section 170. Okay, company is required to maintain this register in the prescribed form where all the information of the directors KMP will be given, okay, as per the appointment and director qualification of director rules 2014. So it should be in prescribed form, should be maintained. So member of the company have right to inspect the register of directors during business hours. So we can say members right to inspect registers section 171. And the last provision is punishment. Punishment is given under section 172. So members right to inspect register during business hours. They can go, they can inspect the registers, okay, extracts they can take from the company, etc. These provisions are given. So if company, okay, contravenes section 149 to 171, the company and every officer who is in default shall be punishable with fine. Okay, we can say if company contravenes section 149 to 171, then company and every officer in default with fine, क्या रहेगा फाइन उसका, ₹50,000 to ₹5 lakhs. That will be the fine. Okay, so these are the provisions relating to the directors. Okay, we have studied, as I promised you. Okay, we have I've just taken you through the various types of directors in between, but we'll try to understand directors in detail. Okay, the few directors we have already talked about in detail, the provisions relating to them, but not for all. So let's quickly go through those provisions once again. So if I say types of directors, so before moving on to this topic, I would suggest you to please write down the pointers if you want. So till 166 we have written. Make a note of all this, 167 onwards. This is imprisonment, fine, resignation of director, removal of directors, and as miscellaneous provisions we have just talked about. So few directors we have already discussed. So like first directors, if you remember, we have discussed first directors, women directors, women director, then small shareholders director, then we'll talk about, I think we have already talked about resident director, then additional director, alternate director, casual vacancy, then there can be nominee director, there can be independent directors. Okay, so out of which we have already discussed the first director, woman director, small shareholder, resident director. Now we will talk about the directors which are given under section 161. Okay, so talking about the additional director, okay, under 161 all these directors are mentioned. Who is the additional director? Under section 161. Okay, so basically all these are given under section 161. Okay, additional director. Now the board of directors, normally so far we have seen that directors can be appointed by the shareholders of the company, but these are some of the directors which can be appointed by the board of directors of the company. So 161 subsection 1 provides for the appointment of additional directors. So if the articles provide or the power to the board of directors, okay, then additional director can be appointed. So but there are some provisions for it. A person who fails to appoint as a director in the general meeting cannot be appointed as additional director. Okay, because it should not become the backdoor entry for the director. Person who fails to get appointed from the rotational retirement cannot be appointed as additional director. So additional director appointed by the board of directors can hold office of the directorship up to the next annual general meeting of the company, and if he doesn't get so his tenure will be till the annual general meeting of the company only. After that he will have to vacate his office. Alternate director is a provision where if a director is going abroad out of India for more than 3 months, then he can suggest the name of the alternate director and the board can be empowered to appoint that person in the place of the director who is going abroad for more than 3 months. So more than 3 months is the prerequisite condition for the appointment of alternate directors. But again this provision can be invoked if the articles specifically give the powers to the board of directors. No person can be appointed as alternate director for an independent director, okay, unless he is qualified to be appointed as independent director. So the person who is coming in place of the independent director should be qualified to be independent director. He shall not hold office for a longer duration than the person in whose position he has been appointed as alternate director. As soon as the original director will come to India, returns back to India, he will have to vacate the office. And again, if he is already holding a position of alternate directorship in the same company for other director, then he may not be appointed as the alternate director. So these are some of the provisions, okay, these are some of the compliances you will have to comply before appointment of the alternate directors. Then in casual vacancy, or you can say nominee director, or in casual vacancy is again given under section 161(4). In case, so if there is a situation where the because of some situation which is unforeseen or unexpected, if the vacancy of the director is there, so at that particular time the casual vacancy results when the office of the director appointed is vacated, okay, or if he dies or for whatever reason, okay, in the normal course of occurrence, then in that case casual vacancy can be filled up by the board of directors if they are authorized to do that. Again, that has to be confirmed, okay, that has to be confirmed in the next annual general meeting also subsequently it should be confirmed. The similar kind of provisions are given over here. Then we will talk about the nominee director. We will talk about the nominee director. So subject to the articles, again the board may appoint any person as a director nominated by the institution. Again this provision is given under section 161. Okay, 161(3). So nominee director, okay, if a person under the provisions of the articles of association, the board may appoint any person as the director nominated by any institution of any law for the timing in force, or by any agreement of the central government or state government. So he can be a nominee person of these such institutes who can be appointed on the board of directors position. So he represents the body which makes the nomination for the appointment as a director. So whenever a company obtains financial assistance from some financial institution or bank, such institution invariably nominates someone, okay, and he will become the board of director for that. So these are the provisions for appointment of various directors, and the last provision is regarding the independent director. So the separate question can be expected on this particular provision of independent director. We'll very quickly go through it. So independent director position is given under section 149, which says that for whom independent directors are required, okay, listed company it is compulsory. So always remember, every listed company shall have at least 1/3 independent directors, okay, and other public companies, okay, other specified public companies, I will use the word specified public companies shall have at least 2 IDs, okay, 2 independent directors. So 1/3 and 2. So if I have 9 board of directors, 1/3 of it is 3. So 3 board of directors should be independent director, or 2 for other companies. Okay. So there can be requirement of higher number, like audit committee where it is mandatory. There can be more number of directors, independent directors. Now independent directors, okay, like the private limited companies have been exempted from the appointment of independent directors. Now we'll talk about who can become the independent director. So an independent director means a director other than a managing director of whole time or nominee director. So there are some criterias, okay, so we can say criteria to become ID is given under section 149(6) of the Act. So who in the board is a person of integrity and possesses relevant experience or expertise, who is not or was not a promoter, okay, of the company, who is not related to the promoters or directors of the company or its holding office or associate office, who has no pecuniary relationship other than remuneration he is receiving, okay, not exceeding transaction of 10% total income, then none of whose relatives are holding any position in the company or having any interest in the company, key managerial position, is not indebted to the company in its holding company, subsidiary or associate company. He has given a guarantee or he has not given any kind of guarantee for that matter. It has no pecuniary other transactions with the company or its subsidiary amounting to 2% of more of the gross turnover. who neither himself nor his relatives holds any position of key managerial, is or not is or has not been an employee or in last 3 financial years. So all these criteria are there. He along with his family members is not holding more than 2% or more of the voting powers of the company. He was not a chief executive or director, okay, of the company, and he should possess some criteria, okay, to become the independent director. So as per the rules of the appointment and qualification of director rules 2014, like he should possess some appropriate skills, experience, knowledge in one or more fields of the finance, law, management, sales, marketing, etc. So he has to qualify that particular criteria. He has to declare, okay, declaration he has to provide, okay, as the independent director. He is entitled for the fees, the sitting fees, okay, reimbursement of the expenses. His term will be 5 years. His term will be 5 years. Okay, he is eligible to be reappointed, and he cannot hold office for more than 2 consecutive periods. So there has to be cooling period also. So manner of selection of independent director is given under section 150. Okay, so as per section 150, along with the rules, maintenance of data bank is provided for the independent directors. Okay, they may be selected from the data bank. So there are various names, addresses given of the independent director, qualifications who are eligible to become the independent director. So such data bank shall be maintained by the body, institute or association as may be notified by the central government. So if anybody wants to become the independent director, he has to enroll his name in that particular data bank. So these are some of the important points for becoming the independent director in the company. So I should mention section 150 as well. Manner of selection of ID under section 150. Under section 150. So data bank and all those provisions are given under section 150. So we have completed this as well. So here we have completed the topic of directors. Not yet we have completed the meeting of directors and all those aspects. We are going to talk in the separate lecture. So I hope you understood. Please make a note of all these points. Just to make it very clear, additional director 161.1 under 161.2 under section 161.4 and 161.3. Just make a note of all these particular points. So today we have discussed about various topics. So we started with section number 164, then we move on to section 165 for maximum number of directorship, duties of director, very important from exam point of view, vacation of the office of director 167, resignation of director 168, removal of director, then types of various directors to be appointed in the company. I hope you have understood all these provisions very well. Okay, so here we have completed the important sections of the directors, and again the meetings or the transactions related to the directors we will talk in the upcoming lectures, upcoming session. Thank you so much for watching this video. To watch this video, read the notes, okay, and prepare yourself for the exam. Thank you so much. We'll meet soon. Till then, goodbye.